Any statement like this is very, very dangerous and very damaging because it is somewhere questioning the entire issue, the entire section of 21, right to live a life with dignity. And also in contradiction to several such directions passed by Supreme Court, where they have upheld such kind of live-in relationship. Now, the other aspect of it is in the case of interfaith couples, or let's leave aside case of interfaith couple, for any couple, if they are going to police for protection, police will always ask for a marriage certificate. It is not feasible because usually police always say, and in our cases also we have produced couples in different states. The first thing which they ask is, okay, first you get married, bring the certificate, we will provide you protection. So I am sure in this also, once the council has argued that we have approached the police and police not helped us, they must have done the same thing. They have referred to section 7A of Hindu Marriage Act. Now, and that's the discrimination when we are dealing with interfaith couples and intrafaith or intra-caste couples. Particularly two Hindu individuals, they can easily marry as per the religious law. Now whether it is quote unquote marriage where the 7 pheras and everything as per ritual takes place, or we have several other forms of marriage which is Satya Shodak marriage, form of marriage, where you have from Maharashtra, or marriage for dignity, which was Dravidian movement where it started. So there are different forms of marriage where there is no such traditional form of garlanding and saptapati is taken place, but marriage has been solemnized, which has been recognized, and it is part of the act which recognizes such form of marriage. And in Rajasthan and some other states, Arya Samaj marriages are not recognized. So the couple from Rajasthan, they have to come to different state to get married. In fact, I would also go to this Special Marriage Act, which also say any form of marriage can be registered under the Special Marriage Act. I think that is the beauty of this Article 21, right to life with dignity. So anybody irrespective of gender, because we have case of Delhi where we had a trans man and a cis female woman. They came together and Delhi High Court has provided them protection in the safe house. So it is irrespective of gender, and we really are thankful to High Court of Chandigarh that they have passed the direction. So it should be irrespective of gender when the people want to stay together. Yes, I mean 18 is something where it is a very borderline case where, so the judge can always take the in the direction that the particular person is a minor, and therefore marriage or live-in relationship is not being allowed. But yes, we know that that whether the judge is also ensuring that such individual or couple gets an accommodation in the safe house, gets the protection. Yes, if the minor boy or girl, they do not want to stay with the family, then of course they can be kept in a child care institute. They have to be produced before Child Welfare Committee, and the Child Welfare Committee will decide. So once a judge is passing such direction, the judge should also ensure that other means and other mechanisms should also be in the place. What is challenging here is that in interfaith couples, They cannot do religious marriage, because if they do religious marriage, they will be penalized for religious conversion, one of them, and the families. And they cannot do the civil marriage, because civil marriage in UP is very cumbersome process in all part of India, including UP. So they are left with no other choice but to stay in protection or hiding from parents. For that period, once they have left, they are staying together. That is considered as a live-in period. But if when you are denying that by saying that the police should do their duty, you are passing a statement which is largely detrimental to larger society, giving a message, also a wrong message. And also, when we know that that Supreme Court has given a clear direction in Shakti Vahini versus Union of India, for which state of UP has already complied. But they are not sending such couples under the protection, under the safe house, but passing such directions. At some states, the high courts are not, or the judges in the high courts are not that progressive. And unfortunately, such cases go to them. They pass such directions, but it is totally against the law and against the directions of the Supreme Court. So that's what I'm saying, that which court is passing direction and how progressive the judge is. Because as per the law, whether the judge is, because they have been, they are the judges, they have passed certain basic criteria to be a judge, to be called as judges and to be there. So they, I presume that they are all aware that it is against the law if they are passing this direction.